requested presence here just to observe the proceedings. Thank you very much for being here, sir. He's that gentleman to the back there with his well mask up, and his name is before him. All right, so I think I should recognize the Solicitor General. Is that her? I can't recognize with the mask, I must tell you the truth. Members of the AG's office. That's more general. Could you want to
if
help
you
us?
can permit me, Chair. Good morning, Chair. Good morning, members and colleagues. I have with me Miss Ashley Marie Auld. It's actually the first time she's ever been in the chamber.
Oh.
So I'm going to tell a little tale out of school. She said it's a little bigger on TV.
All right.
So Ashley Marie Auld is one of our newer members in the Constitutional Legislative Affairs Division.
Oh, excellent. Well, welcome. Good to have you. And because it is your first time, we will be on our best behavior today. The chairman will have the last say on everything, right, Member Guy? He's thinking about it. All right, so now that we have said what we have said, and again, thanks a lot. I know I don't need to remind us of the importance of this work that we're doing. It is a comprehensive piece of work addressing a critical public health issue. And we have, over the past number of months, listened to submissions by a number of stakeholder groups advancing their perspective on the proposed or draft bill. And I think it has been a worthwhile session. It has given us an opportunity as members of this parliamentary group to assess what we have advanced or what has been advanced by the government, and given us the opportunity to pause, to reflect, to reinforce our beliefs or perceptions, or to make adjustments. I certainly believe that in terms of the discussions and how they have progressed to this point, there are only a few areas, but I could be mistaken, that may need some further clarity. And I look forward to that clarity, and will lean somewhat on Mr. Edwards and the team. We've been having some discussions in-house on some of these areas in anticipation that clarity may be needed. Obviously, members will have to express where those concerns may be and what adjustments they may want to propose. But we certainly look forward to that conversation. The other point I want to make quickly before we go into it is the issue of the timeliness of the completion of this phase. I really would want us to quickly go through this so that we can get this in the Parliament, where I think it is long overdue, given the challenges that we have with tobacco consumption in our country. So hopefully we'll be efficient at getting to that point. But welcome again, and thank you all for coming out and for participating thus far, and in anticipation of further participation. All right, so item number 5 on the agenda is reading and confirmation of the minutes of the meeting held on December 1, 2021. It's been a little while since we have been together like this. Happy New Year again, belatedly. And so I'm going to take the minutes, which should be before us, page by page, as usual. Oh, you're not? Okay. Is it clear now? All right. Well, I'm not going to repeat all I said earlier, but just welcome and happy belated New Year. All right, so the minutes are before us, page by page. Page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Seven. Eight. Page 9. Ten. 11. 12. Page 13. 14. And finally, page 15. Okay, so if there are no corrections, can I have
Chair.
a motion?
Chair.
Yes, Mr. Edwards.
Yes, just to what I would call editorial corrections. On page 3,
Page
at
3.
the top of page 3, there's a reference to December 1, 2020.
Which
that
paragraph is it? The extreme top, okay. Yeah,
Yeah, it really should be 2021,
okay.
December 1, 2021.
2021.
And on page 1, our distinguished Solicitor General, in addition to her other titles, I think she is QC, Queen's Counsel, or Solicitor General Marlene Aldred, Queen's Counsel, QC.
QC, okay.
I wasn't taking away the CD, but as adding the QC.
All right. I think during the
But yeah, what is correct?
during the course of the discussion, you may, if you are very engaged with the conversation, you may have to dismantle the mask for a little bit because you're coming across very muffled. Thank you. All right, if that represents the only correction, can I have someone move? Somebody was saying something?
Just on the last page, Mr. Chairman, page 15, the sentence in the last paragraph that starts the acting chairman, 1, 2, 3, 4, 5, 6, 7, seventh line from the bottom, it reads, acting chairman, blah, 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 clarifying the policy intent in light of the information that has been presented. That have should be has. That's just a
Okay.
editorial.
All right. Any other? No? All right, so move for the confirmation. Moved by member Fort, seconded by member Guy. Oh, you weren't here. Oh, Allen, sorry. Okay. Seconded by member Allen. Thank you. All right, so let's move into matters arising from the minutes. Any matter arising? Good morning, Senator. Any matter arising? No matter arising? All right. Going once, twice. Okay, no matter arising. All right, so we move now to the substantive item for the day, which is the the matter for discussion, clause by clause analysis of the bill. And for purposes of efficiency, we're going to do, I'll just mention the clauses, and then you can make your comment rather than reading the clause. Is that acceptable to all members? So we'll just go through one after the other, and then if there is a concern, you raise those concerns, and we address them one by one. All right, so of course, the title, the Tobacco Control Act 2020, and you have the arrangement of sections, which represents page 1, 2 through to 39, and that is on pages 1 or page 2 and 3. Is there anything worth mentioning there? I doubt that, but we then move to the bill, and then the title, and then move to clause 1, which is part 1, preliminary.
Chair,
Yes.
are we going to look at the comments from the stakeholders in the matrix at the same time?
Yes, of
Because really-
course.
okay.
The stakeholder comments were
Will be looked at.
distributed,
Okay.
so all should have those comments. And I would imagine that members would have reflected on the comments. We have a matrix that was distributed to all. Does everybody have a copy of the matrix? We do, yeah. So sorry, I made that assumption. Mr. Stein, you have a copy of the matrix. Would you like one just to follow? Do we have an extra copy?
Copies are being made, Chairman.
Copies are being made, so we'll have one for you. But the committee members do have copies, and I suspect that the technocrats would have copies also. Okay, so we are at clause 1, I said earlier. Clause 2.
Chairman,
Yes.
there's something I learned from going through a previous legislation in terms of dealing with clause 2, that we deal with the other clause, yes, and leave clause 2 for later on, because there might be changes in the respective clause that might impact on clause 2.
Yes, I was actually going to come back to it, but that's good. That's good enough. That's good enough. All right, so let's flip over then to page 8 and go to the object of act, which is clause 3. And clause 3 has A to G.
Just to know, on clause 1, the effective date would be, well, their date would be adjusted to reflect 2022 as opposed to 2020.
Right.
Okay.
Yeah.
Seeing that we're doing it clause by clause, I just thought that would, you know.
No, we welcome all corrections and guidance. No, it's good. It's good. All right, any comments on clause 3, clause 4?
Chair,
Yes.
there is a proposal, as members would see, from corporate accountability, a recommendation in relation to clause 3, the language at paragraph E. So I don't know if your committee members had any thoughts on responding to that recommendation, which was to add some words to paragraph E.
I'm assuming if they didn't comment, then probably they have nothing to add. Mr. Edwards? I'm assuming if they have not commented, then they have not.
Okay.
No, I mean the members of the committee. But are you suggesting that they should reflect more on it?
No.
Oh,
No.
okay.
I was just bringing it to attention.
Right.
Chair, the comment doesn't, certainly by corporate accountability, doesn't necessarily offend the provision.
Yeah.
I would be supportive of adopting it.
You'd be supportive of it. But other members have any comments on that? No comments? Supportive? Supportive? We all have to agree now, right? Or certainly most of us. Supportive? Okay. All right. Okay, we'll go with that. Yes.
Does it affect how the legislative drafts people would have it put? Would that be in order to, if the committee supports this particular expansion of E? Just asking.
Chair, I'm glad that point is raised by Member Guy, because in accepting recommendations and going forward, if the committee does support recommendations, the language, the final text of the language would be, the formulation of the final text is usually reserved for the Office of the Parliamentary Counsel to propose. Because like in this case, we're seeing and or, we would not draft in that way. So the actual formulation would be determined by the drafting office. But the content is what has been agreed.
The content is what is being considered.
And Chair, further, I look at the last part of it and about tobacco industry interference with tobacco control policies. Am I not seem to recall that was mentioned in some other clause? If Mr. Edwards could advise us, because that would be a repetitious in having it in this clause and a subsequent one. But we could take that check on that, Chairman, before, and we could move on while seeing the check on it.
It's just that it doesn't appear. It does appear elsewhere, but this is the objects clause, and it doesn't appear elsewhere in the objects clause, which is a significant clause that governs the interpretation of the whole bill. So it may be useful for it to be inserted here.
To be useful to?
To insert. To keep that language.
Right. Okay.
To keep which language in particular?
Referring to the interference as one of the objects in terms of information.
I was just going to make the comment, Chair, to clarify my support of this this proposed the proposal by corporate accountability, that I was in support of the insertion or language to that effect of the raise awareness to the public, etc., but actually not in support of the second part of that proposal in relation to tobacco interference.
So it's partial support from the committee then, Chair. Is that so?
Go ahead, Member Guy.
I would like to hear more on the members' position as to why this is so. And I mean, I am not necessarily against you, but I just want to hear why is it that you are, Chair.
Member?
Please remind me, Chairman, who is corporate accountability?
They're overseas based, and had requested they made a submission, so we invited them to.
Chair, just to expand on my lack of support for that last part. The language to me and about tobacco industry interference with tobacco control policies, I think imputes ill intent and ill motive to the tobacco industry that I don't necessarily think is appropriate for this bill, certainly not at the object section, because we are still talking about a lawful and legitimate business that's permitted to operate here. So to suggest tobacco industry interference with tobacco control policies, the industry would have interest in tobacco control policies, as would any business that is affected by government policy and legislation promulgated by the Parliament. So it sounds to me in a decidedly condemning way, and that is what would restrain me from supporting it.
And do we have evidence, Chairman, that this is actually so? No, I'm supporting your point, Do we have evidence that there is actual interference in when we have been told, but do we actually have evidence that there is control? And I'm siding with you, So, but
I'm not clear. I'm not 100% clear on that myself, Member Guy. But I'm also not clear on what is intended by interference, because if by interference it is meant that the powers that be are being lobbied by the tobacco industry, but then every industry lobbies government. So would we insert that in our objects if we have not inserted it in any of the myriad of legislation that affect different industries?
All right. Senator.
Thank you, Chair. I am trying to... Good morning, everyone. Sorry. I'm trying to understand really the intent. I'm hearing what Senator Golden Campbell has been saying. But the FCTC, is there a specific reference from there of this inclusion from the FCTC? Mr. Edwards?
Yeah, through you, Chair. This refers to what has been studied and what has been determined internationally as the approach of the tobacco industry in relation to how the tobacco industry as a whole, I'm not speaking of tobacco industry locally necessarily, but the tactics and the strategies of the tobacco industry in countering tobacco control measures. I think this is what the reference to interference was meant to. And
this is why I'm asking.
To. Yes.
Because we're trying to develop legislation and adapt to what we may not be fully aware of in our jurisdiction. And if there is a precedent set elsewhere where we might want to explore the necessity for this, because at the end of the day, there can be interference in terms of the public messaging. Yeah. And that is a technique that the tobacco industry uses.
Yes.
And
yes.
I think I'm wondering if that is the objective reasoning for this being included.
Yes.
So I would like to get some background information on it more specifically.
Okay. The tobacco industry is known to use certain strategies in pursuit of countering tobacco control measures. Among these are...
Mr. Edwards, before you go, please. The member had asked whether this is explicitly stated in the FCTC guidelines, for want of a better word. Can you deal with that first before you explore the other part?
Well, it is stated explicitly in material. Yes, it is. It is. It is. And in articles coming out of WHO.
All right. So
there's a lot of material.
let me hear
outlining.
from Member Malahufort.
Thank you, Chairman. If you just permit me, the proposal is to include language so that that particular provision read, if we take it from the chapeau, the object of this act is to ensure compliance with the convention by controlling the manufacturing, should that be manufacture, supply, advertisement, promotion, and use of tobacco products or relevant products, including exposure to tobacco smoke, so as to inform, educate, communicate, and raise awareness to the public and or any public body about the addictive and harmful health, environmental, economic, and social consequences of the use of the tobacco products and relevant products, and about tobacco industry interference with tobacco control policies. I mean, it's a little long, but I personally have no difficulty about raising awareness about the industry's interference with control policies. I don't have a difficulty with it. Perhaps it could be just reworded for clarity, but it is certainly in keeping with what the law is seeking to do.
All right. If the comments are, yes, Senator.
No, I just wanted for the record to know that it has been read by the minister and it flows so clearly. It further underscores my support for what Senator Golding Campbell's issue is with the term interference, because it has a certain implication there that I am not necessarily comfortable with, but I have no difficulty with the awareness and the public, all that at the beginning. So I just want to register that.
Can I ask a question? Because the the issue of interference is one, I think, that has characterized the discussions around the tobacco industry. So, I mean, I don't know how much evidence we have here in Jamaica, except there are some issues around, you know, the approach to advertising, which came out strongly when we were having discussions, and that approach sought to go below the line. And I'm not saying that other companies or other products don't do that, but that doesn't change the fact that it is an attempt at creating awareness and driving consumption in a manner that could be interpreted as being deliberate, calculated, and intended to deceive. Probably, maybe that's a strong word, but I think also that we have seen definite evidence internationally, evidence being produced by the World Health Organization and others around the industry. It is an industry, we must admit, that is, in a sense, to some extent, fighting for relevance and survival, because the lobby against consumption of tobacco and the science around it and its impact on health is overwhelming. And as a consequence, it is in a constant struggle to try to legitimize and to justify consumption. So it does lead to the possibility of excesses, and as a consequence, I would want to be very clear in terms of the language, given that that possibility exists here, and certainly there is evidence that it takes place externally. So that would be my position, Mr. Edwards.
Chair, if one of the main concerns is the maybe directness or harshness of the language, the word strategy is a word that may be more acceptable. And if one were to speak of the strategies of tobacco industry interests as opposed to tobacco industry interference, maybe that could be more palatable to the committee members.
What injury are we trying to correct? What is the injury that we're trying to correct?
My understanding is that because The Act is seeking to comply with the Convention by controlling tobacco, the manufacture, the supply, advertisement, promotion, use of tobacco. It is, in order to do that, it is going to raise awareness, public education around a number of things, and including the many things, is to make persons aware of how the industry which supplies the product can, for want of a better word, it's tactics to get around.
Manipulate, maybe a good term.
Sorry?
Manipulate, maybe a good term.
Right.
So, but isn't it more than that though? It's more than awareness. It's an attempt at addressing some of these techniques or strategies.
What comes to mind, for example, I'm recalling Dr. Aaron's presentation on what he quite humorously spoke about Carreras supporting the athlete of the year. And I mean, knowing full well that smoking will impact the performance of an athlete. And through a strategy, it's almost as if you are diverting attention away from the harm, because if I turn around and support you, it is unlikely that you're going to take a stance against me unless you are deeply aware of what that strategy is designed to do, so that at the end of the day you make an informed decision. You know,
Mr. Chair, if we are here to determine or to make sure that we have an act that should govern how an industry operates, I believe it might be going further than we should go if in the object of the act we are saying that the object should also undertake to speak to an industry's, I guess this is an extension of lobbying. I think the act needs to stick to the act and stick to the intention of the act, which is to govern how we monitor, manage, and deal with the effects of this act of smoking, and try and separate, because we are conflating two issues that ought not to be. And I would say we should stop at the upper half, if that's a want of a better terminology, to just stick to what the act should be doing, which we're speaking to the health effects, the advertising, all of the other things that we have spoken about in the process.
Let me hear Senator Golden, and I'll come to you, Mr. Edwards.
Chairman, if I could just assist, because the comment was made by corporate accountability, and the comment they made in relation to this interference proposal was really in relation to Article 5.3 of the FCTC, which states, and I will read, in setting and implementing their public health policies with respect to tobacco control, parties shall act to protect these policies from commercial and other vested interests of the tobacco industry in accordance with national law. So that the difficulty I'm underscoring with the word interference is that it connotes an industry acting in a way to acting contrary to or acting in opposition to the law. Now, it well may be that the vested interest of the tobacco is that the tobacco industry is that they don't want this law, and we know that. But it is, I think it's just such a prejudicial word to use in the objects of any act. And I think language, as Mr. Edwards was suggesting, could be substituted to give effect to Article 5.3 as it is stated in FCTC, that would perform the same purpose, but not put us on the other side of the line of prejudice, in my view, for your consideration.
Right. So just before you come in, I just want to remind us that tobacco is like any other product from a public health perspective. And the position that is taken globally, which is my question to you, Mr. Edwards, the precedent. I don't know if you have any information, any precedent around use of that type of terminology elsewhere that would suggest the extraordinary circumstances around tobacco consumption from a public health perspective, because I may have, and maybe this is not the right term, but all right, let me change the terminology. I have as public health and as a minister of health, I have a particular perspective around tobacco consumption as opposed to any other type of consumption. And I think that the general narrative globally around tobacco consumption, certainly from a health perspective, does not equate to the narrative that is used for the other areas of consumption, if you will. So I wanted to find out, is there a precedent around, because I wouldn't want to go light in an instance where we appear to deviate from the norm and therefore send a signal that has a very direct opposite effect to what we want to achieve. That to my mind would not serve us well, or certainly the country well, and would almost appear to side with the tobacco industry, which is not a signal I want to send at this level. Mr. Edwards, what's your point? And then I'll ask you to come in, Mrs. Brown.
Yes, Chair. So, as Senator Golding Campbell pointed out, Article 5.3 directly speaks to the commercial protecting tobacco control from commercial and other vested interests. Now, in relation to examples, other jurisdictions in the region deal with this matter of basically interaction between public bodies and the tobacco industry by proscribing interaction with the industry except where it is strictly necessary for effective regulation, etc. A number of examples we have, for instance, in the UK, in relation to the UK, the Foreign and Commonwealth Office, in its revised guidelines on tobacco for its diplomatic missions, clarified that tobacco industry, it clarified the UK government's commitment to safeguarding its public health policies from the tobacco industry's commercial and other vested interests. So, again, Uganda, in its Tobacco Control Act, sought to adopt tobacco control policies, laws, and programs which, among other things, dealt with tobacco industry interference, and the Act made it the duty of the government to ensure transparency in all its interactions with industry. So that this, the intention really is to adopt the guidelines under Article 5.3 to ensure that efforts are made to protect tobacco control from commercial and other vested interests of the tobacco industry, and that those efforts are comprehensive and effective. Because what was identified, Chair and members, is a number of strategies used by the tobacco industry. Lobbying, offering their own drafts of legislation, using front groups to advance its arguments, making campaign contributions to political parties, making contributions to government institutions, and providing contributions and perks to public office holders, funding conferences and other events, and a whole range of other activities which on the face of it do not appear to be anything more than corporate social responsible activities. But at another level, the strategy has another purpose.
All right, let me hear Mrs. Brownie.
Chairman, my attention has just been drawn to Clause 7(1)(b) of the bill, which speaks to the policy of the government in relation to tobacco control. And I'm wondering, the fact that we have this provision, and it is set out clearly what the policy of the government is in really the public health policy, if we need to become so detailed in the objects clause when we speak about the actual objects of the bill. Because if you look at paragraph B, Chair, it speaks of the protection of the public against the influence of and interference by commercial and other vested interests in the tobacco industry. And I'm wondering if that's not wide enough to cover what is contemplated in adding these words to the objects.
Right. I think it's pretty clear that there is the possibility of interference or attempts at wielding influence. I mean, I think the evidence is supportive of that. The question is whether or not the terminology is used at that level. I'm thinking that maybe, Mr. Edwards and colleagues, we could ask for some further assessment of the terminology and its use at the level of the objects, and maybe report back on it. I mean, I have my own views. I think we should be strong from the get-go and be consistently so. But I'm prepared to look at the precedent and see if it supports that. What I would not want to do is to send any signal at all of that varies or deviates from the general approach in the public health space. That would be my concern. Member Malavu-Fort.
Chairman, I think having regard to the discussion, the recommendation could be accepted on the first part to end at products, at relevant products. And the other part of it, beginning with and about tobacco control, could be rejected, because what that part is seeking to do, as the CPC has, the drafter has said, is kind of covered in the language in respect of the policy goals for the control of tobacco. So I don't think we probably need to detain ourselves with a back and forth on it, having regard to the issues raised and what we're seeking to do. So I would summarize by saying that the recommendation of corporate accountability is accepted in part, and the up to the addition up to relevant products, and the other part from and to public policies would be rejected. And you should have no fear as to mixed signaling or diluting based on what is at 7.1b.
Are members accepting of that proposal? You're good with that? All right, Mr. Edwards,
Chair.
Yes.
Sorry. I have to air my concern. My primary objective is the health. I understand the industry, I do, but I also understand the implications. And when I think of circumstances that I have seen where ads for Carreras ads, other smoking ads are placed just outside or along the routes that are used by school children and so forth, I think that is a primary, and along with what Minister Malavu-Fort just mentioned in terms of the sports awards and so forth. But that, to me, is a direct interference with the objective of the policies that the government would want to try to pursue in terms of the health and the protection of the vulnerable people. So I will go with what the committee says, but I personally think it should be included. I think the word interference might be where my issue is, that it is probably a bit too strident, and it is not conveying exactly the protection that we're seeking, but I think that we should have that recognition that there should be some overall control regarding the involvement or the impingement on the tobacco control policies by the industry. And I'd like that to be recorded. Thank you.
I must say I support the position that you have taken. We just need to achieve a consensus around which is why I was proposing that we do some additional background research to determine if the wording can be in keeping with maybe the convention or with what is a sort of precedent.
Yes.
Would that be a kind of fair position as it relates to reporting back on that before we actually take a decision?
I believe so, Chair. And from the perspective of the ministry, of Health and Wellness also, we note the different purposes of these two provisions. Clause 7 is speaking to what policy should contain. Clause 3 is speaking to public information and empowerment. It's the different purposes.
Right. So I'm gonna propose that we hold on this and do some background work, and then we can raise it again later on, if that's all right. Can we move on then to clause 5? 4, clause 4. Powers of the Minister. Clause 5.
Chairman, I thought we were looking at the recommendations or the issues raised in respect of the clause, so the committee can make a decision on it. That is really what the committee is required to do, where comments are received on a particular clause.
Sorry, I thought we had agreed, but subject to your confirmation, that we would move clause by clause. We would also have the information before us in terms of what's raised, and then the concerns that members may have as a result of what was raised would be taken based on members supporting those concerns that may deviate from what is here in the proposed bill. I thought that was the idea.
So there's also, Chair, what is contained in the matrix based on the recommendations from the respective grouping. And at clause 4, there's also a suggestion around from, I believe, WHO. It says, although the bill establishes a complete ban on the advertising, promotion, and sponsorship of tobacco products, clause 4.1f contains a clause that may be misinterpreted. It is suggested that consideration be given to removing the words "or advertising" in quotation. So again, we have to look at what is being recommended by any stakeholder group that may have made a submission to determine whether or not we accept.
I appreciate that, but what I was saying is that we can go this route. I mean, this is a much longer route, but what I was suggesting earlier was that we would raise the item if it deviated from what was here in the bill, in the proposed legislation, and state the objective. What you're saying is that we should go through all the recommendations that are here. Member, is that what you're suggesting?
Yeah, but if a recommendation...
This is procedural, members, but...
Yeah, but if a recommendation has been made by a group that we would have invited to make submission, we would have to pay attention to that recommendation as a committee to determine if we accept or reject.
Chairman.
That was not, yeah. Yes,
Chairman,
let me hear Senator... Member Guy and then Senator Member Golden.
Okay. Chairman, I was thinking that I want to side with my colleague directly in front of me because you say it's a longer route, but it's a more comprehensive route in dealing with it, because it would mean, therefore, that if we do now agree on a clause-by-clause basis that this is so, what will inform us later on, or what will guide us later on if we're going to look at those recommendations? Because we have already following the route that is being proposed by your chairman, that we would have to go back to that again. So I am suggesting that we look each clause, because I do recall that, and I've made a note in my bill here, Chairman, that there was the concern, and I raised it to too much power to the minister without any parliamentary oversight, you know, and it was a concern that was here. And then when you look at 2.4.2, the minister may by order publish in the Gazette, regulate any design feature of relevant products. That needs an explanation, but that is the least of it. The point is that committee members had suggestions, had recommendations, had inputs as we were discussing the bill earlier on. And these have not really been factored into the discussion except those that have come from external contributions. So the truth is that we need to have a comprehensive look at every clause as we go along, and that is how I see that we're going to
Okay, member, it's not a contentious issue. Yeah, it's just that I thought that we had agreed on a path, but that's fine. We can further clarify.
Chairman,
Yes,
I'm not seeing any distinction in what all three are saying. My understanding is we are going through it clause by clause, and while we do each clause, we will look at the recommendation for each clause so that we cover the matrix clause by clause, and we're going in numerical order of the clauses. I don't think, as I'm hearing the three of you, you sound to me to be saying the same thing.
Okay,
so that's the agreed position.
Let's recalibrate then and identify the areas that where concerns have been raised by the presentations, our presenters, and then we can invite comments if we think those comments are warranted. All right. So we look at 4 and the WHO's suggestion. There is a clarification issued by the Jamaican Psychological Society. There's Carreras and the Chamber in terms of recommendations, concerns, and so on. I'm going to ask members, therefore, in looking at these submissions, are there any comments further, starting with the WHO's position?
Chair?
Yes, Mr. Edwards.
And we will note also that we have a second sheet because the matrix is in 2 parts. So there are also comments from the Jamaica Psychiatric Association, JMEA, and Boot to Go. So it's 2 documents we have to be looking at simultaneously. Chair. Parts 1 and 2. Chair, if I may just comment on the approach.
Go ahead.
I am sensing, Chair, that there is a concern among members that there may be some restriction in consideration of issues to what is in the matrix. And I know, Chair, that is not your understanding. The matrix is really an indication of the stakeholder comments, but of course the members of the committee, it's an open opportunity for members of the committee to independently comment, even raising issues that are not in the matrix. So I wasn't sure if that was the concern that, from a technical perspective, we were hearing, that members felt they were not open to.
No, Mr. Edwards, my thinking of it is that, yes, as it relates to a particular clause, members may have their own interpretation or their own recommendation that they would want to advance.
Separate from anything
Separate and apart from the recommendation made by, or the opinion advanced by a stakeholder.
Yes.
So, as a matter of procedure, when we reach a particular clause, we can either advance our own thought in relation to that particular clause and determine as a committee whether or not we're going to either reject or accept the recommendation by a stakeholder. So it's a question of just going down the road and making sure that once we reach a particular clause, every aspect of it is considered.
All right, so, member, again I say, there is no restriction or attempts at restricting members from commenting on any clause and expressing any opinion, whether related to a submission or any additional position that you have. I thought that was a clear position. However, if I understand the member correctly, supported by Member Guy, you want us to actually mention each of those comments that were made by the respective presentations and add to that if so necessary, in order of completeness and perhaps for the record as it relates to the deliberation. Is that what you're saying?
That's what I'm saying, Chair. I just don't want us as a committee to miss a comment or a recommendation or an opinion by any stakeholder who would have, taken the time out to make a submission.
Okay, so we're at 4, and 4 has a number of suggestions, recommendations, starting with the WHO clause 4.1f and the issue around the issue of advertising, promotion, and sponsorship of tobacco products, and the need to remove the words "or advertising." Are there any comments on that?
Chair, from a technical point of view, we support the amendment proposed because it would be inconsistent with a prohibition to speak of regulating the prohibited activity. So we are okay with that proposal being accepted, Chair.
Are members okay with that? Okay, I must see an affirmative. Yes.
Could we have the full reading of the clause then? So, Mr. Edwards.
So the clause would read, clause 4.1f would now read, subject to the provisions of this Act, prescribe controls in relation to the labeling, packaging, sale, or distribution of tobacco products and relevant products, etc.
Okay. And then the Jamaica Psychological Society asked for clarification. The Minister of Health and Wellness seems to be the most relevant party being referenced, and this should be made explicit throughout the document. Is there ambiguity around that? I'm not so sure.
I don't think it's...
No, I don't see that either. Huh? Well, we're going through everything as you have asked. So please don't complain now. All right, so we move on then. If there's agreement.
Chair,
and then yes. Someone was saying something?
I'm just noting a comment was made, and when I read it, I had to consider 4 is really talking about the power to make regulations. And ought not what is in 4 be part of that general regulation making power, which is near to the end of the bill, 30-something, I think it is. 37. Because that comment about it, it didn't say whether it would be by affirmative or negative resolution. All of that would be cured if we just keep everything that is to be prescribed at one place. It's very odd for it to be here, in my view. The drafters can indicate.
All right, so we'll ask them to take note. Mr. Edwards, I don't know if you want to comment on that or it's clear enough. Sorry,
Mr. Chair?
Is it Miss Brownie or Brown? Brown. Even with the E at the end?
Sorry?
No, sorry, go ahead.
Yeah, I take Ms. Wilkins' point. It's a matter of style. We can all put it in one part of the legislation. It can be, I've seen it done like this also. We've drafted like this also, but we'll look at it.
Okay, all right.
Chair, is it simply regulations though, Ms. Wilkins, or is there any contemplation that the minister is implementing measures that may not be legislative in nature that may be policy-based through the ministerial function that he holds. Because that is how I read it. Not that this was 5 was intended to be a part of the powers to make regulations set out at 37, but that in implementing the intents of the FCTC, this paragraph was intended to indicate that the minister ought to do those things to effect A, B, C, D, etc. And I didn't have a distinction. I did not have it. I did not interpret it to mean legislative in nature. And if that is an interpretation of it, then I would be supportive of keeping it, because there are non-legislative measures that the minister would be able to.
I think, member, because of the use of the word prescribed.
4.
That has a specific...
I'm sorry. I'm speaking to 5. I am speaking to 5. My apologies.
Okay.
All right. Can we move on to the Carrera's comments recommendation? What's the final position on the Jamaica Psychological Society? That's what I thought. Yeah. So we overruled that position. The Carreras Limited.
Chair, it so happens that I don't necessarily hold any brief for Carreras, but my concern, as I have it in my bill here in the note, is the powers of the minister, right? And I too feel that there has to be some overarching, whether it's a parliament or some grouping that will determine, and I think I'll go back to Ms. Wilkins' suggestion as to how it would apply. Would it come to the parliament? Would it be a situation where it's resolution under what basis? You know, so that is my concern about that. But to say, yes, I see them, but I mean, I'm not influenced by their thing. It's just my thinking. To say that the minister, notwithstanding the provisions of any other enactment, the minister may. My main concern is, how does the minister do? You know, how is that may affected?
Chairman, if I may, and also member, the recommendation from the Jamaica Chamber of Commerce on the other side may also help in that. In accordance with the best practices, any regulation the minister proposes ought to be the object of consultation, where all interested parties are given an opportunity to be heard.
At 4?
Yeah, that's 4. So it's the recommendation from the continued recommendation from the Jamaica Chamber of Commerce.
Chair, if I may.
So it provides the avenue. Where is that?
No, so it supports the point I'm making. How is this affected? Mr. Edwards,
enabling such consultation.
Chair, if I may.
Go ahead, Mr. Edwards.
Thank you, Chair. The use in Clause 4 of the word prescribe brings in the regime under the Interpretation Act, by virtue of which, once power is given through a prescriptive measure to any authority, minister or any other authority, it is implied that that power is a legislative power. Further, Section 37, Section 4, Clause 4 has to be read in conjunction with Clause 37, because Clause 37 specifically empowers the making of regulations in relation to, let me just read it, in relation, make regulations for prescribing anything required by this act to be prescribed. So the magic word is prescribe. So the contemplation is that the power given to the minister under 4 is to be exercised within the context of the regulation making power under 37, and then further under 37(2), that regulation making power is controlled by being subject to affirmative resolution. 38 is yes, 38 is also a controlled power in relation to penalties, yes.
Okay. Is that sufficiently supportive of position?
Mr. Chair, just a question to Mr. Edwards,
Sure.
because as it reads, there's obviously room for misinterpretation, because I wouldn't have picked up that it is referenced in section 37. Is there some way to integrate that into clause 4 to make it easier to read and understand? I put it to the technical team.
I think the proposed legislation has to be looked at in a holistic way rather than parts of it being interpreted for particular, for fear that you misinterpret if you only extract parts of it. I don't know what the comment is, Mr. Edwards. You want to comment on the, or Miss Brown?
Mrs. Brown from CPC.
We can, Chair, incorporate these provisions in clause 4 in 37 so that it reads as one. What Mr. Edwards is saying is correct, but for even more clarity, we can just insert them in 37 as the regulation power, making power provision of the Act.
Okay.
How, Chairman, how does 4.2 now? Does it follow the same path?
No, it doesn't share. That is distinct. That's a distinct, separate power to regulate design features. And that is by order. So that's a different instrument. That's a different process. So it's not regulations. It is different.
May I,
Madam
Chairman, I've always been curious from my time in another office. What is the practical difference in style between saying that you're prescribing something which tells you through the Interpretation Act mechanism what it actually means, and by order, since regulations are defined to include orders? I mean, I know, I always wondered from a draftsman's perspective, what is the difference? I know the legal implication, but tell me from the draftsman's perspective.
Or usually, to you, Chair, to Minister, the order is often a less, how should I say, less elaborate in terms of process, how it is presented. An order is usually, it may be long, but it's usually prescribing information as opposed to going into a lot of provisions that may deal with penalties, procedure, etc. Because regulations in many ways can mimic the structure of an act. So an order is usually, oftentimes you see it as a list of information, prescribing steps or outlining details which don't go into a lot of procedural matter, but is usually just prescribing information. So in this case, you see regulating design features. It's a fairly circumspect legislative instrument as opposed to regulations which are usually much broader in scope than just prescribing information. So an order is usually very specific. It will usually prescribe, something like fees or prices or basic steps, as opposed to regulations which, as you know, Madam Minister, can be much more elaborate in process. So an order tends to be usually prescribing information, oftentimes in a list form for convenience, as opposed to regulations which can go into sanctions, administrative procedures, and much more detail than an order would normally.
Thank you, Mr. Edwards, for that clarity and definition. Can we summarize then what our position is as it relates to the Psychological Society? And I believe we made a link between that position and Carreras and the Chamber. Are we agreed that it is covered?
Chairman,
yeah.
we agree the inclusion of the Minister of Health is superfluous. The bill is actually piloted by the Ministry of Health and Wellness, and any minister referred to there is explicitly stated. Now, if it were the Minister of Finance now, then that would speak for itself in the bill if one particular clause related to the Minister of Finance. But I don't think we need to say the Minister of Health.
So your recommendation is?
I would leave as is.
Leave as is, yeah. All right, so we're agreed on that. Mr. Edwards?
Yes, Chair.
Okay.
General principle of law that Member Guy referred to speaks of the minister being the minister with portfolio responsibility.
All right, and I think the next item of recommendation would be from the Jamaica Psychiatric Association, which looks at clause 4F2, where it reads, prevent injury or harm. We suggest a change to, change to minimize injury or harm, as one cannot definitively prevent injury or harm to the health of the user of tobacco products or relevant products. This is recognized to the inclusion for the protection of non-users, but persons who are exposed to secondhand smoke. And so we suggest a possible section 4F3 rationale for this. Secondhand smokers are at high risk for the consequences of tobacco and nicotine exposure, and as such, minimize injury or harm to these persons should be highlighted in the Act. Comments? I suspect that Senator of the same profession would like to comment on this.
Well, being the president of the Jamaica Psychiatric Association,
right.
I fully endorse, and I will leave it at that. I'll allow the other members to comment. Thank you.
Members? It's really a recognition of the impact of secondhand smoking.
And Chair, remember that there's also the phenomenon of third-hand smoke. Huh?
Yes, of course.
But we did not go there. But we want to at least protect for second-hand smoke.
Right. I have no issues with it, with what is recommended, unless other members have a comment. Mr. Edwards, any comment there?
Can I get a read of it now, Mr. Edwards, if
Mr.
we
Edwards?
agree?
Chair, but I just had a question, though, and of course, I defer to expert Senator Longmore in relation to whether both could not appear, because you're saying through your association, Senator, that we cannot have definitive prevention. Is that the understanding? We cannot definitively prevent injury?
We cannot have definitive prevention? I'm not too clear.
No. The suggestion was based on the inability to definitively prevent injury or harm. So I think we are just seeking some clarification on that inability to prevent.
Yeah, so it is limited to prevent injury or harm to the users of tobacco products. What we're highlighting is that there is also injury and harm to second-hand exposure. There's no protection of the second-hand exposure in that section there, in that clause.
Okay. So I was wondering, we couldn't have both? Provision for prevent or minimize? Would it be inconsistent to have both?
I don't think so.
Okay.
I don't think so.
Okay.
So what's the rephrase?
So, well, Chair, it would read so as to prevent or minimize injury or harm to the health of the users of the tobacco products or relevant products.
That wouldn't cover
Well,
what
what
you're
about
asking.
Huh?
So it would be users on second hand.
Go ahead, Ms. Brown. You're trying to comment.
I was dealing with the first element of the recommendation, not the second element.
Just to add to what Mr. Edwards was saying, Chair, you can just add where we have health of the users or second-hand users.
Second-hand exposed.
Oh, yeah, well,
Exposed.
I'm not drafting it now, but it will be incorporated in this
Yes.
provision.
Yeah. So what we're requesting, as recommended here, is the specifically reference second-hand exposure, and I think it's important. So I would support that. Okay. So where would you include that? You would add an additional section.
No, Chair.
Okay, you'd incorporate it.
Yeah. Incorporate
Okay.
it into.
All right.
But just that we still make provision for prevent or minimize.
Okay,
That
fair
would be
enough.
inconsistent. I just wanted that clarity from
All right.
Senator.
So can we look then at the JMEA? For the purpose, can you repeat what is being recommended, Mr. Edwards? Or Ms. Brown?
Yeah. So we...
That was addressed
So we
in
yes,
the
Chair.
37.
Yeah. So we are adding minimize in subclause in subparagraph 2. So it will be prevent or minimize, and where we speak to the health of users or second-hand exposure, words to that effect, so that we prevent, we incorporate second-hand exposure to tobacco products or relevant products in that same clause.
Is that acceptable?
I thought we had covered that.
No, well, we wanted to make sure.
Now you move on to the JMEA.
No, we're going there now. So the JMEA again speaks to the power of the minister. I think we have done that. We have covered that. So we can, unless there are any comments, move on to boot to go.
Question, Chair, through
yes,
you.
go ahead.
Parliamentary Counsel, is there, if we use the language second-hand smoke, would you?
I made an error when I said that. I was speaking of second-hand exposure.
Second-hand exposure.
Yes, 'cause smoke, yes. It was my error because I...
Okay, would you define that? Would that require an insertion in the definition section?
Maybe we need to in this particular provision.
Yes.
Yes.
All right. So we've added a definition to the recommendation. Okay. So can we boot to go? This concerns. Oh, it's the same issue. Okay. All right. So we have addressed that. I'm trying to be as thorough as possible to satisfy Member Cavan Gale, Senator. All right. So can we move now then to clause 5, where the government to undertake comprehensive nationwide education and information campaign. I don't think there's no recommendation here. I think that's pretty straightforward. Clause 6, actually this is education campaign in schools, pretty straightforward. Where is it? Let me look to see. Hold on. Let me see. Hold on. I don't see it here. Okay, so Ministry of Education, Youth and Information. speaks to a number of recommendations here. Section 6, in addition to the institution of learning, stipulation of institutions where youth are regularly facilitated. And they think that therefore it should be a broader term. Juvenile detention centers and other such places. Can we take the points one by one? Any comments on the broadening of the term?
Minister,
Yes.
Mr. Chair, I'd agree with the broadening of the term there, because I believe that, as they say, it would provide for a more inclusive outline of spaces that engage young people.
So it's taking the learning process beyond the formalized classroom setting to places where young people gather, but that could mean a lot. It just has implications for the budget, right? What's your thoughts?
Just relating that the recommendation from the JPA included places of entertainment, recreation, and sports, which also would be where a lot of young persons would gather. So I don't know if we could just incorporate both. That might be, and places of learning, institutions of learning.
Well, it would be institutions of learning, entertainment, etc., etc. So it really would have to say where young people are gathered to kind of capture all the. Mr. Edwards, how would one do that? Or is that addressed elsewhere?
No, Chair, it is
Chair, I was just...
not addressed.
One second, Mr. Edwards. Yes,
I was just going to add that young people gather everywhere. So having it as that broad may pose an issue.
Right.
But, Mr. Chair,
yes.
Could I note that it says institutions, not just places. So I think it would provide for, as Senator Longmore said, spaces where you have recreation, spaces where youth are engaged in sports, places where, for example, you have police youth clubs. So I think the institution there...
Is that the intent? I'm just wondering though, is that the intent of the clause, or is it an attempt at focusing on our institutions of learning? Now, I do agree that institutions of learning could be a lot bigger than a school, but I wonder if we do not water down somewhat the focus on where young people gather to learn and to be taught. So the Council on Drug Abuse, Mr. Tucker, who is here, you have a task at addressing the drug abuse or usage within the school environment, and you do the annual school health survey, which clearly indicates that we have a problem. And one of the core objectives of our mandate is to get in the school environment or the learning environment young people to recognize the ill effects of consumption of tobacco in any way, shape, or form. And I really want us to place emphasis on that, because I believe the reward is expansive if we can get them at that stage, or young people. I don't know what your thoughts are, but I do agree that institution of learning is more than just a school.
So let's deal with the practicality of the campaign and, presenting the information. So it speaks about carrying out in all schools. So there's an approach in the schools to lead the campaign. It speaks to the workplace, so there can be a process or procedures to lead the campaign. And it speaks to in all communities. So there might be avenues within communities to lead the campaign. But if we get granular in terms of entertainment spots, now, who is going to carry out the campaign in the entertainment spots?
Well, I would imagine that the entertainment spots are in the communities.
So, then go in a sports club or things like that. Let's not be granular. I think this is wide enough for us to accept.
Yes.
in
That's
terms
my
of
view. That's my view.
applying a
But let me hear
procedure.
other members on this. Yeah, member Guy, and then
When we had the first go through the deliberations, there was a thinking that in 6 we could disaggregate in schools, I mean that is the educational institutions, and a B in communities and workplaces, so that we would be looking at those specific areas, but have them subgrouped, you know, so that the focus on one can be that and the focus on the other could be that, and then capture everything.
okay, let me hear from Senator.
Thank you, Chair. The main concern, and I know we're dealing with the Ministry of Education, but we kind of started to talk around entertainment, recreation, and sports. The main concern is that some of the interference by the industry tends to target especially those events for their promotion and to strategically hook young people and to attach themselves to something that is psychologically positive in terms of recreation and sports. And so we have a great concern of that attachment in that kind of vicarious way that, you know, the individual later on finds it hard to detach the association. So I think our objective was to specifically relate that, especially in those areas, that we have that type of protection.
Chair, may I just
let me, yes, Ms.
Look, if you look back at 5C, 5C include media professionals. If you look at the categories in 5C, it may allay some of that concern, because if the campaign is going to be targeted to these groups.
Right. I get the impression, though, that the struggle here is to determine how we capture young people. I think education seems to have represented the best attempt at a definition of our youth and the impact of influence on our young people, who in turn will develop habits over time and have a difficulty. So, Mr. Edwards, while I do agree that there needs to be an emphasis on our schools, which perhaps represents the most significant vehicle for young persons to interact, at least during a certain cohort, you know, is there a way to not water that down, because that is so important, I believe, but at the same time capture that youthful cohort in a way that is more all-encompassing? Because I think that's what we're trying to achieve. Member Golden, yes.
Chair, can I just say, though, that the provision as it is drafted now in capturing, as Senator Gale outlined, schools, other institutions of learning, workplaces in all communities and in all communities, is broad enough, is my view, that it will capture those things. But let's be careful that we are not seeking to insert in the legislation that which is really properly done as a matter of administrative decision-making in terms of the policy of how you roll out this kind of campaign. Because at all times I ask, what's the purpose of the provision? If the purpose of the provision is to prohibit or restrict a behavior, then there must be a sanction. If it is simply to notify, then it notifies and there is no sanction. But what is the purpose here? Really, just to underscore in the legislation that the information campaign must be wide and far-reaching, must touch and concern the youth and target the youth. And how that happens is really administrative, not legislative.
Any comments? Yes, Mr. Edwards.
Chair, following on from Senator Golding Campbell, we are wondering...
Hold on, Mr. Edwards. Maybe I should get... You want to hear him first? Okay, go ahead.
Yeah, we're wondering if Clause 6 could be assisted if we had words not drafting no, but words to the effect that this provision is in addition to any other measures, in addition to any other measures implemented under Section 5, the education and information campaign shall be carried out in all schools. Because 5 is intended to be quite a broad, swath of options, of measures. And 6 is really seeking, at a minimum, to ensure that it happens in schools and other institutions of learning. So if we were to say, in addition to any other, measures implemented under Section 5.
Is that just a psychological remedy you're providing, though, Mr.
No,
Edwards?
it's not a psychological remedy. It's
No, I asked the question because at the end of the day...
partly psychological.
At the end of the day, if the Ministry of Education or the Ministry of Health does not do this, what is the remedy for me as a citizen? Can I take it to court for failure to do it? What enforcement do I have for whether you do it or not? It's really a policy issue. It's really rolling out of the policy. So it doesn't offend me for it to be in the bill, but it's not a legislative measure. So adding to the clause any further than this really does not affect anything, because at the end of the day, it's what the minister's policy in the ministry rolls out as the education and information campaign.
Except that the clause, if it captures a kind of mandate, could be used as a significant criticism of the lack of policy or effective policy to support it. So from that standpoint, I could appreciate a more elaborate wording to capture the issue. But I see both positions. I do believe that the schools are important, or the learning institutions, because I think that's an area of emphasis. But
Chair, if I may maybe offer a bit of a consideration of a compromise, because I do recognize the broadness of entertainment and recreation, but especially sports. If we can stipulate around that, because just as Senator Golden indicated, I think it is also relevant and pertinent for us to have the policy to protect, especially, and recognize that we know that these are the hot spots. These are the points that once the person is exposed, they tend to remain attached to the association. So I think that if it's even to include sporting endeavors, because it is so critical there, I think entertainment and recreation is not necessarily only youth. I will give that. But sports is primarily that.
Member Malahufort, you had a comment. I should have called on you before, sorry.
No, Chairman, just so many things have been said, but when the law provides for something, it's not mere policy, it becomes a matter of law. So between 5 and 6, what are those provisions seeking to do? Places a responsibility on the minister to implement measures to do certain things. And in addition to those, it is targeting areas where those measures should be effected. So the schools and the places of institutions of learning and workplace and all communities. Your policy team could help us with what really is the policy intent for naming the schools and other institutions of learning and the workplace to determine whether you go wider. Because when you look on the Act in its totality, a massive campaign is to be mounted right across the jurisdiction so that persons are aware, so that specific information is provided, and at the end of the day, they may make informed choices. So I'm kind of not so sure what the haggling is about.
Basically, you're saying it should remain as is. Pretty much.
I'm saying that if the intention the policy intent behind Clause 6 is a targeting of these specific areas, in addition to what the minister is mandated to do through the implementation of the measures, then it appears clear to me. I do appreciate the desire to name other places where persons will gather, but I read this a little differently, that it was a specific targeting of those areas. And it doesn't mean that other areas will not be covered, because generally you're blanketing the entire jurisdiction.
I'd like to ask Mr. Edwards a question, Chair.
Go ahead.
So, Mr. Edwards, in 5C speaks to who is going to carry out the education campaign. And there's a catch-all statement, other concerned persons. Now, 6 is speaking to where. Did I hear you make a suggestion in terms of other areas? To include communities and other areas as part of your recommendation?
No. Well, it could have that effect.
Well, 6 says that.
To you, Chair. But no, I think what Senator Gale is asking is if I had proposed adding other areas to what is here. But I'd actually done it in the reverse. But it could have that effect, where I said, in addition to any measures implemented pursuant to Section 5, the education campaign shall be carried out in schools, workplaces, and communities. So it was really just to open it up beyond just what is specified here. Yes.
But listen, the only reason to specify additional is for emphasis, because 6 captures everything. So the only value proposition here is if we feel, in our wisdom, collective wisdom here, that it is very important to mention, sporting activities or places of entertainment. So let's make that determination. And because I think that's really where the discussion is. Is it necessary? Because this captures everything. Is it necessary to specifically mention places of entertainment, sporting activities, and then you say communities, for example, to kind of mop up everything else?
Minister, I need to go back to the purpose of the provision, and consequent on what Minister Fort has said and what Mr. Edwards said. Is the purpose of this provision to identify the places, or is the purpose of the provision to indicate that the information and education campaign must be far-reaching? Put those as my header questions. Let me follow that with, if I go to Janga High School, I don't want to call any particular school, and there is no information and education campaign rolled out in my high school because for whatever reason, nothing has come down from the ministry to fund it, no materials have come, whatever. What can I do as a school to ensure that that happens? How can I force that budgetary spend on my school? So hold on. So I'm asking the committee to think about the purpose of this provision. If the purpose of the provision is simply to indicate the intention that the bill must be supported by a properly set out policy that outlines how education and information is going to be targeted and directed at these people, then can I propose this for the committee's consideration? That instead of trying to expand the targeted areas, that a requirement be put into Clause 6 that the minister must, at some point after the bill has come into force, lay in the Parliament, is it the green paper is the final one? Yes. which would set out the policy in relation to the education and information campaign in schools and so on. And there could be a requirement in that regard that that policy be updated every 3 years or 5 years or whatever time period is appropriate, and that the minister would lay that paper in the parliament. Now that there gives you the teeth, minister, that you are obligated to do it. Citizens are aware of that obligation, and if you don't do it, then you have breached your own act. So I put that to the committee for consideration, depending on what it is that the policies what policy is intended to be affected by Clause 6. As I said, and I just recap, if it's simply putting out the targets as to where you're going to do it, this more than sufficiently covers it. If it's intended to say we're doing it, we intend to support the bill by doing this, then you intend to support the bill by doing this, and nothing more needs to be done. If we want to ensure that there's a policy that comes to public attention that has a well thought out set of steps as to how the minister and the budgetary support behind that, how you're going to do that, then that is properly, I think, a subject of a policy paper laid in the parliament, and we can require you to do that over a period of time for your consideration.
Members?
Weighing. I'm just looking, and Mr. Edwards, you probably can help us here. Clause 5, and I will refer to Clause 5 in my discussion on 6. The minister shall seek. If the clause had said the minister shall implement measures to and outline all of these, then you would need 6, or 6 could just stand on its own. But if he shall seek, is there not a way that at 6 you should also put shall seek to do similarly, so that the points raised by Senator Golding wouldn't put the minister under pressure if those policy decisions are not really laid and effected?
Except that I don't mind putting the minister under pressure.
Thank you, Chair. I think I don't know, maybe I am a little bit lost in the legislative agenda proposed, but the concern for me here, the purpose, and as Senator Golden indicated, in terms of the purpose of the clause, the purpose of the intention, is to seek, I think, to as best protect the vulnerable. We're dealing with an issue where, just as we include schools and other institutions of learning for the purposes of those populations being the ones most at risk, the inclusion of sporting activities, I think, and I said I will yield at entertainment and recreation because that also includes other population groups, but especially sporting activities. The fact is that the reason why we recommended these is that these are also not just hotspots for the advertisement, but also for the use of the substances.
The challenge I have with the position, member, is that if we were targeting just the actual athletes and players, then it would be you'd be accurate. But the truth is, every age cohort attends sporting activities, and I agree with you that sporting activities are a sort of prime location for promotion of this kind of activity. But remember now, there are other ways to control some of these things. So you have no smoking, for example. Is there the regulation, the bill speaks to smoking and no smoking areas. So we could address some of those concerns there. There is entertainment. I would think that maybe entertainment has more younger people sporting activities, except of course for the participants and maybe the entertainers themselves. So I'm not sure if either one is more important as it relates to the activity of the tobacco company trying to promote its products at those locations. But I do believe that we should target those locations. The question is, do we emphasize or do we assume it is captured under the all-encompassing sort of community engagement?
I think the rationale for emphasis of it, because we could always have said all communities, and that would have included schools and other institutions.
Yes. No, well, schools
so
are,
likewise, the same logic, I think, obtains for why we should.
Well, if that were the case, we should say sporting, entertainment activities, and which was the third one? Recreation, and then say communities. Is there any injury in doing that for emphasis, just adding those three specific locations? Anyone, members? Let's try and solve this one and move on. Yeah. Mr. Edwards.
Chair, the intent, and I'm going back particularly to Senator Golding and Member Guy's comments. The intent really is under Clause 5 to create the obligation to undertake this campaign. But it's not a hard obligation. It's not a hard obligation. And then under Clause 6, the implementation, the carrying out is provided for. So you have the general obligation to seek to implement these measures. And in 6, the implementation is located in specific areas, specific places. The challenge we may have from a technical point of view is that the places that are identified are fairly settled in terms of being institutions, workplaces, communities. It's anticipated that when we speak of communities, we're speaking of establishments within communities, you know, the post office, the hospital, whatever. Now, a place of entertainment, recreation, and sports, we may have to have language, if the committee wishes to identify these broad areas of activity, we may have to have language that somehow captures a sense of institutionalization, so to speak. So it would not just be at an activity, but at a specific place where these activities are routinely carried out. So I don't think from a technical point of view we have a problem with the concept, but it's just a matter of these activities, the place, the location of it being implemented would have to be somewhere that is of an institutional or settled nature.
Boys and girls jump start today, going to the stadium as part of a campaign. I think we run the risk of, you know, making a commitment that we might not be able to deliver, and that be entrenched in the legislation. So that's my concern, that we widen it to that level of, you know, being specific to which we cannot commit to. And so I'm satisfied with what we have here right now in terms of an approach. Maybe policy decision later on, Chair, can expand, having met the targets that we have set out here. The policy decision can expand later on, depending on how it goes.
Okay, any other comments? So are we going to allow the clause to stand as is, recognizing that schools are identified, other institutions of learning, which could mean any physical location, workplaces, and all communities throughout Jamaica?
Chairman, I would say perhaps you may want to, because it doesn't mean that your campaign cannot be done in other places. It just means that you are mandated to do it in these places.
Right.
So unless, of course, the intention is to mandate that it be done in other places. But I would hope that in rolling out the legislation, given what you're seeking to achieve, it would be a rollout.
It would be a national rollout, but
children are vulnerable. So in schools, for example, at the time when they are being shaped in a particular direction, you really want to put the information to them in a very targeted and very specific way so their choices can be informed. And then you would minimize, if not eliminate, some of the difficult problems around NCDs and around habits and the addictive nature of the consumption of tobacco, as the information put before us indicate.
All right, our members agreed on that. I know there are some different opinions. Member?
Chair, I again will go with the committee, but I will voice that I am against that decision in this case. I think at least the exact thing that Minister just said, that this is serving to indicate where we find the emphasis to mandate, and especially where there are vulnerable populations. And in my mind, absolutely,
the only,
absolutely
as I said, I take the point, and I do agree that these events, sporting events being one of them, tends to attract subtle, overt, if not covert attempts to promote tobacco consumption. But I take a similar point for entertainment events. And I'm saying if we're going to specify sports, we should also specify entertainment events. Now, if we're agreeing on that, then we'll just add that to Clause 6 and for emphasis. Then there's the issue of, can we enforce? Well, I mean, we certainly can attempt to enforce it. I mean, there are many examples of, you know, the difficulties of 100% enforcement. Indeed, I don't think it's practical. But I do believe that there can be attempts, and indeed, the inclusion may force the attempts at emphasizing. So unless members want to include those two, I would not include just sports. I would say entertainment. That's my view, if you want to emphasize.
Chairman, don't we have non-smoking areas in public? I mean, isn't there a general ban on smoking?
I raise that,
public?
but it's not about smoking.
I understand.
Remember, it's
your
promotion,
campaign.
it's education,
right.
Public education.
I understand. So tell me now, is it that when an entertainment activity is held, you're going to hire one of the performers, perhaps like the one you were photographed with, to sing a special song against
I was a
persons consuming?
but okay, I'll accept it for what it is.
It would be a very effective strategy. Exactly, exactly, Minister. Very effective strategy, that.
I was certainly there, and I do believe she's a talented entertainer. But nevertheless, that's for a different conversation. But
I'm just wondering. We're not laughing it out. It is clear. All I'm saying is that bear in mind that a duty is being placed. You know, we're good at legislating things, and we're not so good at implementing them. You know, with the same fervor. Our law books are replete with many things that should be done that are not done. So I'm saying this does not preclude campaigns being done in other places.
Right. No, I agree.
But
I agree. But let me just give you the Minister of Health's perspective. I'm here as chairman of the committee, but the Minister of Health's perspective, which aligns to the professional public health member on the committee. I've heard a lot coming from the other public health member, but but the truth is that there are places where vulnerabilities are greater than others, and sporting activities, and I dare say even more so, entertainment activities, because I believe entertainment activities actually represents a more vulnerable place to promoting consumption of tobacco, and so to mention one and not mention the other, to my mind, wouldn't do sufficient justice. So it's either it's captured in the general description, or if you really want to emphasize, then you'd have to at least go with those two. That's my view.
Chairman, can I ask a question? And I would direct this probably to the Solicitor General. In the event that the Minister does not implement measures at Clause 5, and therefore there is no education and information campaign carried out in schools, what happens in the society? What is the import of that on the Minister, or on the fact that this is now a provision in law? Grateful if you could opine on that.
Not sure I can give much assistance, but the way it's phrased, it's not a statutory duty. If it was a statutory duty and it's not done, then it would mean there is a breach of a statutory duty. I don't see this as creating a statutory duty on the Minister. It's just saying that he shall seek to implement measures, not that he must or he shall. So there is no breach of statutory duty if it is not implemented. So the consequence would perhaps be Parliament. All ministers are accountable to Parliament. It can be raised in Parliament. But it's not a breach of a statutory duty.
But I take the point Member Golding is making. Is it a clause that would be elevated to that kind of burden or responsibility on the Minister? That was the concern I had with what you had recommended. I take the point and understand the implications of making it a requirement. But remember now, in the democracy that we practice, there are many stages of being held accountable, including the ultimate being political and elections, or cabinet reshuffling and all the other things. So the Minister would have to consider, yeah, it's true, the Minister would have to consider that if he has a responsibility, he's either effective in carrying it out as adjudged by the executive arm and the chairman of the executive arm, the Prime Minister, or in a broader sense, the public. And I do believe that those components of our democracy plays an important role in terms of holding accountability and pressuring for enforcement. Getting to the level of a statutory duty, is there precedence for that in the law and in this particular?
Sorry, I think the distinction the learned Solicitor General was making is that the language use, this doesn't place a duty on the Minister to actually do something other than to get something done. So it's not the Minister who is going to do it, but the Minister is going to ensure that it is done by someone else.
Right, I was referencing what was recommended earlier by Member Golding.
Sorry, can I just clarify? There's no statutory obligation placed, and I think that's a good thing. When I look at what is being required here, it would be very difficult to standards to then make it become a statutory duty.
That's the clarity I was seeking, and I was referencing what Member Golding had originally proposed. Huh? Yeah.
This does not mean that the work to be done is any less important.
Absolutely not. And hence the debate and the prolonged discussion, relevant as it is, as to whether we include, for emphasis, sporting events and entertainment events, or we allow it to be as is, where it is captured but not emphasized. That's a decision I'd like us to make. And I'm going to pull Chairman's privilege and ask for
go
a
right
decision
ahead.
as quickly as, as possible.
As it is, Chairman, I believe that it captures. To get specific might not suit us. I think as it is, it captures it.
Okay. And
Chair, yes, thank you. And I'm very glad it is known, because my primary objective is the behavior change that we're trying to adapt to, which is one of a predisposition to addiction. And I think that that has to be recognized in the places where such predisposition is most likely. And it would be, I think, a lost opportunity for us to emphasize, especially at the ministerial level, what that focus ought to be for our young people especially. So by all means, I am not in agreement with it remaining. I would want to see places of entertainment, recreation, and sports included.
Chair?
I just wanted to add that I've been listening, and the catch-all phrase basically would have encapsulated all that we have been discussing. But I don't see any harm in including sporting and entertainment, and then we can just move on.
Okay.
I'm in support as well, Chair.
So just include it and let's get on.
It does no harm.
Chair?
yes. I think I don't want you to interrupt the emerging consensus, Mr. Edwards, because for fear that we go over it again. So I'm assuming that there is an emerging consensus. And I know Member Gale is deliberating in his mind, and he doesn't mind adding the two particular area for emphasis.
Chairman.
I'm prompting him for a response, but he's an original-minded person.
You see,
so
where 5 says the minister shall seek to implement, in my mind, is the safeguard. That even if we were to expand it, it doesn't compel in any way if the minister don't meet it.
So it achieves the issue of emphasis, but still doesn't guarantee implementation, which is what we seek. The objective is for emphasis, right?
And what this is seeking to do is to promote behavioral change.
I'm big on that. All right, so can we then find a way, Mr. Edwards, to include those two areas and rephrase and let's move on? There's another component to this bill becoming legislation, of course. The Parliament, so we can debate it. All right? Go ahead, Mr. Edwards. You want to rephrase?
No, Chair, I was just referring to the fact that we have language of that nature in the second schedule, which speaks of sport, athletic, recreational facilities. So we could adapt similar language to this provision. The second schedule, which speaks of places where smoking is prohibited, and it refers to sport, athletic and recreational facilities. So we could make some adaptation of language and incorporate, if that is what the committee desires.
I wish you had reminded us of that an hour ago, but okay.
No, but Chair,
thank you very much.
45 minutes.
We have about half an hour. I think we have to close by 1. All right, so can we agree on that? And move on then. The other comments made by education, clause should be included that provides some meaningful engagement of youth in the planning, implementation, and evaluation process of the education and information campaign programs. Do we need to include that in? Do we need to include that in the? Sorry. That's my view also. I mean, is there any other comment on that? Can we just accept that then? And then another one, along with educational campaigns, a section should be included that speaks to monitoring and rehabilitation of offenders charged under this act. In this scenario, however, the NSSC and JUTS are primarily concerned with parents, relatives, youth may become charged, monitoring at risk situation. Again, it comes across, huh?
We have the Criminal Justice Administration.
I think this is
court, etc.
Yeah, this is speaking to what already is accounted for in several areas. So could we just accept Is there anything else? Oh, I see. Is there anything else from education? All right, so I think we can move on from the comments from Ministry of Education, Youth and Information. If we're accepted that we have made one adjustment, which is the emphasis on sporting and entertainment events, the other two would be accounted for in policy. The final comment...
Chair, may we just be clear, events or facilities? Because event is a one-off activity. Is it facilities? Okay, thank you.
The final comment on clause 6 is the Jamaica Psychiatric Association. Oh, well, okay. We've been spending all this time dealing with that. No wonder you were so insistent, madam. All right. I'm told that we have to close at 12:30, which is exactly 30 seconds away. We will? Oh, well, you're agreeing that we need to close off at...
Chairman, I would suggest that since so much time had elapsed between the last meeting and this one, between this and the next meeting, members could just use the time to refamiliarize with the provisions, and then we can see what we'll have some consensus around and what we may wish to deliberate on a little longer in the interest of time and in wrapping up the deliberations of this committee to report back to Parliament.
Thank you for that intervention, member. So we will move from item 7 to any other business. I want to just reemphasize what Member Malahoo Ford said. I know that it's been a while. We have all the documentation. I really would like to get through this phase, like all of us to get through this phase in probably another 2, maximum 3 sittings. The date proposed for the next meeting, next Tuesday, what date is that? 12? Next Tuesday the 12th
Next
at 10?
Tuesday is the Tuesday after, it's not the Tuesday after the holiday, I see.
Yeah. Right, so can we make a note of that day, if we're all agreed? And we will continue with clause 7, and hopefully we'll take it further than 6 clauses on the second sitting, because we would have been very familiar with the material. Any other business? No other business? All right, so it's for me to say to members, the next sitting will be the 12th, next Tuesday at 10 a.m. And I'd like to take the opportunity to thank you all for your participation. I really appreciate the different views. I think it's important. So even though I'm trying to push a completion, an early completion, I think it's important that persons express themselves and consider thoroughly all the elements as it relates to the presentations, but also your own views. It's a very important piece of legislation. And I would like, when we get to Parliament, we're at one in terms of the positions taken. So don't mind my insistence about moving apace. Let's do our jobs, and I don't mind the delays if necessary. Thanks to the technocrats who are here and who will continue to be here over the next few weeks, and of course to the Parliament. And at 12:32 and 38 seconds, meeting is adjourned. I ask for a motion. So moved Member Guy, seconded by Member Malahoo Fort. Thank you very much. Have a good day.